I'm Steve Lee. I'm the director of the Injection and Mining Division in Louisiana. I appreciate the opportunity to speak today, to speak to the board, tell you what we have going on. Preface things a little bit. When this entire effort started, I was director of the Injection and Mining Division for about 6 or 7 years before 45Q was passed. And I had exactly 0 inquiries in those years about CO2 sequestration. Since that time, it seems like it takes up at least half of every day. I know that I've met with well over 50 companies at this point who have shown interest in CCUS in Louisiana. A lot of those companies have gone to what I consider a phase 2, which means they've decided that they do not want to actually actively inject and sequester themselves, but they want to partner up with somebody else. And I'm actually getting companies now coming to us saying, can you point me to a company that is in my area that seems to be interested and are injection well savvy that I could partner up with that may take my CO2. So we're seeing an evolution here, which is not unexpected. But we started the Primacy efforts immediately after 45Q was passed. And my staff has worked very hard, very diligent. We have worked actively with the EPA. They were very good. They set up like an ad hoc committee and their own people to help us expedite this process. We moved it through, I think, at a very fast pace. We have submitted our final package for Primacy to the EPA. We were expecting a final decision last fall, November, December. But as I'm sure you know, there's been new administrators appointed with the COVID challenges. We have not received a decision yet. The word I'm getting is everything's okay. It's just that things don't move as fast as we would like to. When you're dealing with government, especially the federal government, I know you're all very much aware of that. But right now we're in a position, we're waiting for that final determination. So in addition to that, other things that we are doing at this point to try to prepare for the issuance of Primacy, we've been working on some supplemental regulations. This would be a separate set of regulations that would augment those that have been accepted by the EPA and a part of our Primacy project process. We don't think that they will impact our Primacy in any way. It has nothing to do with technical reviews or technical standards, financial surety. What they will do right now, they will deal with 2 separate topics. Number one is our fee structure that we're going to put together for the review of these applications. And the other one is confidential business administration. And they're kind of an outgrowth of statutory changes that happened in our last legislative session. As far as the fees goes, we were granted the ability to subcontract to outside vendors to help with the review. And then the second part of that was that we were given the ability to charge the applicant the state's actual cost, up to the state's actual cost to perform the review. So we're going to be putting together, we're going to be fleshing out what that looks like by regulation. As far as the confidential business information goes, the statute says that anything that's accepted by the EPA as confidential, that we would also treat confidential. And this is kind of an outgrowth of the fact that we plan to use the EPA's GSDT, their geologic sequestration data tool, their online submittal tool for our permit reviews also. So we want to give the applicants some sense of confidence that information that they feel is confidential that they can share with us, and we can also hold it confidential at the same time. We will be qualifying vendors. We're for outside third-party reviews. We are stepping through the procurement process. We're trying to work that out in-house before we begin that. Any of you who's been involved with any type of government procurement process will know that it's not a simple task to both qualify a vendor and get some type of contract in place. But we are working that also. Other things that we're working on right now, We've already entered into a three-way, well, actually probably a four-way talks between Texas's Railroad Commission, their Environmental Quality Group, the Region 6 EPA, and ourselves for a memorandum of agreement, how we are going to handle applications that have cross-border impacts. Because yes, we have already talked to people who we know that if they give us an application, there will be a cross-border impact. We've initiated those same talks with Arkansas and Mississippi. We're further along with Texas right now, but we're trying to get those in place as quick as we can. I do know that BOEM, the federal offshore, they are beginning the process of putting together their own federal regulations. We're a little bit premature, we believe, for a memorandum of agreement with them, but I also foresee that in the works in the future, that that's something else that we'll be dealing with. Another thing that we're dealing with right now, we have a effort between Region 6, Texas, and Louisiana to map in GIS all of our Class 1 plumes, and that's going to be both hazardous and non-hazardous. There has been some issues within the last few years of Class 1 hazardous plumes being impacted by Class 2 injections, most notably up in Northeast Texas. And so we want to be able to identify these so that we will know the impacts of any CO2 injection in these areas if they're going to impact these plumes. And we're putting it on a GIS system. We want it to be readily available to the public and to all of our applicants, anyone looking for CO2 sequestration in either Texas or Louisiana, to have this information at their fingertips to be part of the planning process. Another thing that we have going on right now, you mentioned the other energy minerals, hubs, energy hubs, hydrogen hubs. We are also working now on regulations in order to be able to permit solution mine caverns for the storage of ammonia, hydrogen. We also included nitrogen, compressed air. In Louisiana, anything that we put in a cavern has to be called out by statute. So the last legislative session, we had all of these different constituents added so that we could move forward. Now, these will be Class 5 caverns. I know that Texas has permitted them as Class 2. And Mississippi also has recently moved toward Class 2 permitting for hydrogen caverns. And their laws read a little bit different from ours, which I've seen Texas's laws before, and I can see where it is permitted under what has been approved by the EPA under primacy and their law. We don't have those laws. Ours are a little bit different. So right now we will have to permit them as Class 5. So that's kind of it in a nutshell. I want to leave some time here. So any questions that you have, I'm happy to take them. The other thing that was sent to me of things that you could do to help us. I'd like to know if you have any questions before we move into my list of things that we would love to have a little bit of help with.
Hey, Steve, this is Richard. Thanks for that. That's just exciting news to hear all that. I did have a couple real quick questions. Number one, are you guys able to handle the entire permit review in-house? Or are you going to have contractors like EPA has for the reservoir modeling part of it?
Right now, my expectation from the interest that I've seen and the companies that have been requesting is that I expect within a year of us gaining primacy, I expect us to probably have at least 15 applications, 15 facilities. We are expecting these reviews to take anywhere from 1,000 to 2,000 hours, man hours. Some people would say that it equals to 500 woman hours. I'm not going to go there, but we do know that they're going to be very intense. I don't think at this point, what we're expecting is that we will do what we can in-house, but with that number and the number of people so far that we've been able to add, we're almost going to be like project managers for a lot of it. So yes, I do see us outsourcing a lot of it, and unapologetically, environmental justice is going to be one of them. Okay, we're technical people. We expect to bring in specialized firms for that. I expect that, yes, we will be bringing in people to help us with the modeling and probably other parts of the review also. Because our goal is to try to get these applications turned around as fast as we can. And with the new statutory changes, which allows us to basically bill back to the applicant the cost of the review, I think we can outsource most of these applications. And once again, our desire is to turn them around as fast as we can. We are hoping to have a turnaround time between 1 and 2 years for an application of this complexity.
That sounds good. And I had one more quick question on financial assurance. Or do you have to follow the exact same procedures that EPA is following on establishing financial assurance, or do you have some flexibility there in your understanding?
I don't think we have a lot of flexibility because we have the same regulations that they do. What we do have is there are fewer financial instruments that will probably be acceptable to us than to the EPA. This is one of the areas where we differed from them. We also, because in the Office of Conservation, we have financial surety for Class 1 wells, caverns, oil and gas wells. We have all of these other financial sureties, even for coal mines. And in all those instances, we require either a letter of credit, a surety bond. People can put up a CD for the amount of money. Specific to oil and gas, you can do a site-specific trust fund. There is a provision for that in our statute, but it's only when you transfer the facility to another operator that seems to be an avenue that you can use. So I expect it will be follow the federal requirements pretty closely, and but there will be probably fewer financial instruments that the commission will accept.
Yeah, my takeaway from hearing you speak is that I have a kind of a newfound understanding of the difficulties that states have. You know, we all want states to go get primacy, and we're saying, why don't you guys get primacy? And so there is a lot to it. And I mean, it's a huge undertaking. I'm starting to appreciate that more and more from hearing you speak. And maybe that's a part where this consortium can kind of help other states, and other states can reach out to you and, you know, and help them so that it doesn't take as long and it doesn't take as many resources on their behalf.
I've got a question, if I can ask it. Scott Anderson, EDF. So early on in your primacy application process, we were told by Louisiana staff that EPA had told Louisiana that starting with Louisiana, that they were going to include some EJ provisions requirements in the primacy agreements. And so we struck up a conversation with EPA to try to find out what they were planning. And they basically would neither confirm nor deny that they were going to do this. But I still assume that they are working toward making their minds up of what they want to require of states. I'm curious if you have any updated information. How clear of an impression do you have of what EPA is likely to require on EJ?
Okay, this is my understanding, and this is the way that we proceeded. Early on in our primacy process, they were asking us, and this was the prior administration, whether or not we were going to do an environmental justice review. The new administration came on, and we had not actually made the decision, but we did make the decision that yes, we would perform an environmental justice review. We included that in our primacy documents. We had some standards that we put in there that basically defaulted back to the federal standards. As far as a requirement, at that point, it was not my understanding that it was really a requirement. It was not put to us that way. Maybe the reason is because we went ahead and agreed that we would perform an environmental justice review. As far as any additional review criteria or anything like that, I'm not aware of it. I know that they did come back with us. They had some comments about environmental justice. Most of the comments that we got were during our public hearing from NGOs and third parties and citizens. And we tried to address those in our comments. But the environmental justice, as I'm sure you know, it seems to be pretty fungible right now as far as exactly what's going to be required and what form it's going to take. And we are anxiously awaiting that information.
Gotcha.
Do we have any more questions for Steve?
Well, maybe not a question, but I just want to take this opportunity on behalf of Southern States Energy Board to say how much we appreciate Steve's appearance here today and the fact that Louisiana has taken such great and outstanding leadership in this area to serve as one of the early states, early movers to go ahead in this area, and also pledge all the resources of the Southern States Energy Board, Steve, toward the work that you and your team are going to be doing, and anything we can do to assist, we'd be very, very happy to do so. So again, thanks for your appearance here today. Yep. And we appreciate what you're doing and what's happening in Louisiana.
Well, thank you. And really that brings me to part two. One of the questions that was put to me before is like, what can the Southern states do to help us? What can applicants do to basically make your life easier, to make this process move a little bit smoother? And I have a list of about 3 things here. And number 1 on my list is something that you, in your opening remarks, you've already touched on. You have subject matter experts with your members in your membership, and the entire CCS is such a new undertaking in so many different ways that the way you could help us, we are always looking for subject matter experts to speak with us about different technical issues. We've been drinking from a fire hose on this thing for the last 2 years. And I think we've made a lot of progress, but there are still areas that we would really like to have, be able to speak to and have some guidance on. The input of some of these subject matter experts. It may be anything from the modeling of the plumes to completion criteria, plugging abandonment criteria, any of those things. We have been actively looking for people that know more than we do to help us out, because we feel like the more we know when we go into the review process, the smoother this thing is going to be, and especially if we're all kind of on the same page. So that would be an area where you could help us. Of course, if you put together some subject matter experts, we would always welcome other states to sit in on the discussion at the same time. You know, we're not necessarily asking that you just come and talk to us, but I think that most of the other states are probably in the same situation that we are, in that we're trying to figure this out as we go. And we know we don't have all the answers at this point. So we would like for your subject matter experts to be able to share some of their experience. Another area then this gets down to the applicant. Please come in, have a pre-application meeting with us. We know the geology of our state very well, and there are areas that we are going to discourage any type of CO2 sequestration just because of oil and gas activity that may be going on there, geologic issues that are very well known and very well documented in the areas. And if a potential applicant comes in and speaks to us about that area on the front end, a lot of time we can save everybody a lot of time and a lot of expense when we tell them the issues that we see with it. Or it may be an area that we look at and we say, you know, it looks really good, guys. We don't know of a problem, to give them some confidence moving forward. So, and probably the third area is when you get in an application, give us a quality submittal. The way we're setting up our fee structure, the applicant is going to end up having to pay for a lot of the review anyway. And you can pay once or you can pay 3 times. You can pay someone to do, huh?
That's exactly right.
You can pay somebody to put together the application, then you can pay a contractor to review it, and then you can pay a consultant to do it again. And it will save everybody time if it's a very, very good submittal on the front end. Perform your due diligence, and hopefully it will go through very smooth, very fast. Because from one thing that I've gleaned from talking to all these applicants, their biggest problem is time. And so we want to cut down that time as much as we can to bring all of these applications to a permit decision, whether it be thumbs up or thumbs down. We want to move them through fast and expeditiously.
Well, thank you, Steve. We happen to have subject matter experts in all the areas that you have discussed, and I look forward to working more closely with you guys as you continue in this quest to get primacy.